Has a price.
Thank you.
Everyone does.
Welcome, everyone. Welcome back to the Committee on Housing, General, and Housing. House, General, and Housing. And it is still Wednesday, April 2. And as our last item this morning, we're going to hear from Judith Dillon, who's Executive Director of the Labor Relations Board. Welcome, Judith.
Good morning.
What I'll do is let's have the committee introduce itself to you, since I don't think you know the people in the committee. You want to take this thought?
Absolutely. Good morning. I'm Ashley Bartley. I serve Fairfax and Georgia.
Leonora Dodge. I serve Essex and the City of Essex Junction.
Joe Parsons, Groton, Newbury, and Topsom.
Hi, Tom Charlton. I represent Athens, Chester, Grafton, and Wyndham.
I'm Debbie Dolgan. I represent St. Johnsbury, Concord, and Kirby.
Good morning, I'm Gal Pezzo. I represent Chittenden 20 Colchester.
Hi, Emily Krasnow, Chittenden 9, South Burlington.
Good morning, I'm Mark Mahaly, and I represent Calais, Plainfield, and Marshfield. Judith, you want to introduce yourself?
Yes, hi, good morning. My name is Judith Dillon. I'm the Executive Director of the Vermont Labor Relations Board. I've held this position for just shy of 4 years now. So I can go into detail about the board, or I can answer questions, whatever you would like.
I'll tell you what, let me set the stage for you. We've been hearing, this is called general and housing. General means all kinds of things that don't go anywhere else, but one of the major parts of that is labor. And in that regard, two things. First of all, I do think it would be good to hear briefly from you about how the VLRB works.
Mm-hmm.
One of the major issues, it's clear from various testimony that we've received, that there are concerns about the capacity of the VLRB to handle things. Assertions that you're backed up because you don't have enough personnel, et cetera. And so letting us know what kind of a backlog you have in terms of unfair labor practices or complaints, contracts, et cetera, and giving us your thoughts on that issue would also be of use.
Okay, sure. As you know, the Vermont Labor Relations Board has jurisdiction and adjudicates matters involving the 7 labor relations management statutes. We get involved everywhere from the petitioning stage, from whether or not employees want to form a union and select a representative to represent them in negotiations on terms and conditions of employment with their employer, to adjudication of grievances with respect to the Vermont state employees, as well as Vermont state colleges and universities. We also get involved in unfair labor practices involving all of the statutes we adjudicate. And we finally get involved with impasse determinations, which I think is the focus of the legislation I was provided, but where folks, labor and management, are trying to negotiate an original contract or successor contract and they can't, and an impasse is determined. They reach a point where, golly, they can't quite agree on everything and there are some issues to be determined. The board, with respect to state employees, can order a mediator. If that doesn't work, they can order a fact finder. So that's generally what the board does. In the past year, I'll just talk. When I started, at the same time that I started in 2020, there was a significant change in the labor relations election statute that inadvertently prioritized those cases because there's a very strict timeline for those cases to be heard and decided. And that had the, I think, unintended effect of kind of pushing grievances, unfair labor practices to behind them in terms of priority. So the board has gotten behind in adjudicating cases, but in the last year, the board has endeavored to try to do its best to resolve that and, resolved and adjudicated, or cases were reached a resolution between the parties in 68 cases, which, is considerably greater than the year before, the 3 years before. Right now, if you would indulge me, just because I didn't prepare this, so I didn't pull this sheet up in anticipation of today's my presentation, I will find for you that information as I'm multitasking, trying to toggle it up. But we do have one case, unfair labor practice case from 2022 that the board has yet to issue a decision, which it will be in the near future. The bulk of our cases are from 2024 and now 2025. So if I haven't pulled up that record, that document I'm looking for while I'm talking, before the end of today, I will provide you with those statistics of where we are regarding how many cases we have, unfair labor practice cases, and how many grievances we have, and the dates of those cases. And I think maybe to keep my focus on you today, it might be better if I follow up with that information rather than pulling it up. But generally, the bulk of the cases are from 2024, 2025. We do have some cases for 2023 that we're working on. One of the challenges, even though we have been fairly successful in the past year of resolving 68 cases, 2 of our neutrals have resigned, and one of them announced their intent to resign a year ago. And their term officially ended last June. We've been grateful and privileged to have this person, Alan Willard, to continue working for the board through January. He's indicated that he'll continue to work through January. Our other neutral resigned at the end of last year. So the selection.
Judith,
Yes.
let me ask you, is the neutral used for fact finding or mediation or for what?
No, for any matter that the board adjudicates, it needs to have a panel of 3 members. So you need 1 neutral, 1 management representative, and 1 labor representative. So for unfair labor practices and grievances or unit determinations, which happen in the context of when a new petition is filed, one of the issues the board decides is whether there's a challenge to the unit. For example, is there a supervisory employee or a confidential employee, or perhaps this isn't an appropriate bargaining unit. You might have professionals in with custodial staff, and it's a fairly large, for example, municipality. Small municipalities, that might make sense, but for a larger municipality with divisions of labor and expertise, that might not make sense. The board gets involved in unit determinations. So with respect to fact finding, the board can conduct the fact finding, or the board can appoint a fact finder. If the board were involved in fact finding, again, that would need to be a three-member panel. I have heard that the selection committee that provides the governor with a list of names for potential board members has advanced a number of names to the governor, and we're hopeful that we will get 2 new neutrals in the next month or 2. We have our next set of hearings. We have hearings scheduled in June, so we need a neutral before June. 2 neutrals before June,
Yeah, I
ideally.
got to ask you a couple of organizational questions.
Sure.
I'm pretty ignorant when it comes to the details of how you function, so forgive the basic nature of this. So what is the function of the board as opposed to the staff? In other words, what does the board do? What does the staff? I understand you do grievance contracts, unfair practices, impasse, mediation, fact-finding and unit determinations, but I don't have a clear idea of what the function of the staff is in regards to those things,
Sure.
whether the neutrals are staff members, whether you,
No,
and
no,
what the function of the board is.
sure. So the Vermont Labor Board has 1.5 staff members. I am the full-time staff member, and there is a part-time clerk. That is the entirety of the staff. The board members are provided with a modest stipend, and they are the ones who, if there is a hearing, they are the decision makers. They hear the hearing, and they they deliberate, and they come up with a decision. Because our board members, none of our board members are currently lawyers, I, as an attorney, I advise them and provide them on the standards, evidentiary standards, rules of procedure, substantive law. I provide them with a primer on labor management law whenever on every and all cases. I sit in the hearing room. I assist the board member, the board chair that is serving as the chair for that hearing in resolving procedural issues, evidentiary issues. I actually, once in a while, I will actually ask questions to help clarify, perhaps elicit testimony that might clarify an issue that is otherwise seemed confusing. And I also sit in on deliberations. Once the board decides, makes its decision, I write the decisions, the board reviews the decision. So whether it's a unit determination, a grievance decision, an unfair labor practice, discovery orders, motions to dismiss, I am the one who writes all of those decisions. The board makes the decision, I write the decision. I'm also the chief cook and bottle washer for most everything else, determining budgetary issues. I oversee the board clerk who intakes new cases. I help work out scheduling orders. I help figure out what board members we need when for what hearings. So the actual work, writing work of the board is done by me. It'd be great if I could share it, but right now it's me. And the board clerk handles purchasing, paying invoices, that side of the operational budgeting aspect.
Is it a subset of the board that hears each case or the full board?
No, with each case, so there are 6 board members. We have 2. The statute provides that we have 2 that are management, coming from a management background. We have 2 that are coming from a labor background, and we have 2 that are neutral, excuse me. For each hearing or each matter that needs to be adjudicated by the board, we have 1 representative from each on that panel. Ideally, we like to circulate it so that the board members are sharing the load. So it has, in the past 9 months, it's been a challenge, and Alan Willard has taken on the lion's share of the matters because he's been the neutral that's been available.
So when you say neutral, you're talking about a board member.
A board member, exactly. And having said that they're coming from that background, it's been my experience, and all of the board members look at each case and decide it based upon the facts and the law. Their background informs them, but they're each looking at the case fairly and objectively. So, but it's
the governor appoints the board members.
Correct.
You have, and so when you said earlier you were concerned because you had 2 neutral resignations coming up, the governor will have to appoint 2 new neutrals, right?
Correct. And the selection panel, which is head by the Commissioner of Labor, I've been informed. I don't know how much I can share, but my understanding is that some names have been forwarded to the governor. Obviously, that the governor makes that determination on his time, but that's my understanding.
The labor board, the labor, who again is the selection, heads the selection panel?
It's a group, I apologize for the title. It's headed by the commissioner of the Department of Labor, the court administrator or her designee, the chair of the Vermont Bar Association. There's representatives from, I believe, labor management as well,
Okay.
who they recruited, sent out the applications, and reviewed those folks.
Committee, do you guys have questions of the administrator, of the director?
Yeah, I do.
Please go ahead, Joe.
All right. Once a dispute comes to you guys, can either party ask for extensions in the process?
Yes.
Or is it a?
Yep, and by disputes, it would be either a grievance or an unfair labor practice. And
Yep.
it's been my experience that once a discovery schedule is set out and the hearing dates selected, it's not unusual for one side or the other to request an extension. Reasons for that may be we're in the process of engaging in settlement talks, or our witness has a health family issue, our commissioner has a conflict, we couldn't get a deposition. There are a myriad of reasons for extensions. So the extensions may take place during the course of the discovery leading up to the hearing, and the extensions might also follow the hearing itself. Let me just pause for a moment. One other factor that has contributed to some delays is, and I don't know what, one factor is many parties, I hesitate to say most, but many parties request a transcript of the hearing to assist them in preparing their findings of fact. So after a hearing, the parties usually submit a findings of fact to the board that's their argument and proposed findings for why the board should rule the way they want the board to rule. So folks want a transcript. Unfortunately, there aren't a lot of court reporters, so there's a bit of a delay. For example, we had a hearing in August, the end of August, I believe, and the folks requested a transcript. They filed their briefing in December. So that causes delay, so.
It sounded like you were saying it seems pretty evenly split between employer and labor. That's
Yes,
the
and
back and
usually,
forth of asking for
yes,
extension.
it is pretty evenly split, and it's been my experience, or what I've observed is most of the time the other side acquiesces and says we don't oppose it, or they may even join in the request for the extension.
And
Go ahead, please.
is it the board that approves the extension or the length of the extension? Do you have specific criteria you look at?
Well, we try to have it be tied to the reason for the request. So, there are times when we deny. Let me just back up. There are times when we've denied the request, and that's if the hearing has already been noticed. And so once the notice of hearing is out, which usually comes, 30 days or so before the hearing, the party that's requesting it has to demonstrate why they want the request. If a new, something has arisen regarding a council or a party that they're now unavailable and it's through no fault of their own. For example, if someone has a medical emergency, we had a lot of that during COVID, a medical emergency, that type of thing. But we have, in the recent past, we have denied a request to change a hearing date after it had been noticed because the reason given was it had nothing to do with either with a party, and they didn't explain the need for the continuance. But most of the time, the board will grant it if it's close in time and it's tied to the reason. So if someone is sick, let's try to find a hearing date, for example, a hearing date as close as possible. But again, when we move a hearing date, we have to find a neutral labor and management that are all available at the same time. And when we have a full board, we usually schedule out potential hearing dates 6 months in advance. And so we have some wiggle room. Because we haven't had that in the past, 6 or so months, we've kind of been like, we have an issue, we have a case, we need a hearing, let's get 3 members. Are you available this day, this day, this day, this day? It's been more, on a case-by-case basis as opposed to having it 6 months in advance.
Yes, go ahead.
Did I answer your question?
And
I'm
then
sorry.
Elizabeth.
Yeah.
Yes, you did.
Yeah, I was wondering, again, you said that you've been there about 4 years, but what's the longest, maybe even in your time, that something has taken the board to make a decision?
Well, it's, I think you're asking me, well, there are 2 parts to that question. I'm not quite sure which one you're asking me. How long it takes a board to make a decision from the
The
time.
filing.
Okay. I can get you that answer. I don't have it off the top of my head, but I will answer that. And I'd also answer the question, how long it takes from a hearing. That might be helpful to you as well.
Yeah, both would be helpful. Thank you.
Sure, I'll provide that to you.
Appreciate it.
I have a guess, but I don't want to give you inaccurate information.
Oh, of course. Thank you so much.
Yeah.
Elizabeth, you have a question.
Oh, I just want to clarify, with regards to the delays due to transcription. You don't have to use a court reporter based in Vermont, is that right?
Correct.
And
There's
so hasn't that delay been somewhat mitigated by the ability to record hearings and then send them to a transcription service somewhere else in the country?
no, we do rely, we have one local reporter that we don't usually have access to. So most of the times when we're, at least 50% of the time when we're doing, having a transcription, it's sent to this regional entity. It's like a pool of reporters. So it hasn't cut down on the time.
Okay, thank you.
Any further questions by the committee? You're looking thoughtful. Do you have a question?
Not regarding this, no.
All right. So to sum up, I think you, as I understand it, you'll provide us data. You should send it to Magali Stoll-Aleman, who is our committee official with whom you've been corresponding, and send that data over to us, and she will distribute it to the committee. I guess my last question is, as I remember, or I've heard, there is a proposal for perhaps $250,000 for more staff for the board. Is that in the Senate budget, or where is that?
I don't think it's, my understanding is the money piece was taken out. That's my understanding from staff for Senator Carlson's committee. Clarkson, I'm sorry, apologies. Senator Clarkson's position. I think it was Senator Rom Himsdale who made the proposal. The proposal was for one other attorney to share the load in educating the board, attending hearings, assisting in deliberations, writing decisions, and also helping to do education and outreach, which is something that the board or board staff can do. A part-time web designer and case management developer clerk. So that was the focus of it, because we don't have an electronic case management system or docketing system, unlike that you might see in the court system. For years, it was done on a piece of paper. We have, when I came in, I converted our paper filing to electronic filing. So, but it's all,
Wow.
it's all email. So that took some time. It's all email generated though. And we still need to manually input, when things are due, triggers. So we're looking at, what other, for example, the Human Rights Commission and what other boards have done. We have some carryover funding that we're hoping will allow us to make the initial purchase price. But the maintaining of that, the current, the clerk position as it's currently written, the skill set doesn't quite match what would be needed. So our thought was having, a part-time position who can maintain that upkeep, and also the Labor Relations Board website, which has been very helpful to practitioners and employees and employers, so that they can access, there's basically chapters on unfair labor practice, grievance, how to file a petition. It's, we want to continue to maintain a robust website. So that's why we were looking for a part-time position for that.
Is, when a decision is made on a grievance or an unfair labor practice, et cetera, is that decision public and published?
Yeah, so you can go to the Vermont Labor Relations Board website, and there are decisions, and under decisions you can look. We're currently in, what's known as volume 38, but last year's decisions were in volume 37. So you'll see I think 21 or 22 decisions that were published there from last year. So yes, some things aren't smaller decisions. For example, well, they are published, but in a different way. For example, if there's a new union certification, that's published on the website, but not as a decision. It's published under the collective bargaining heading, and then you can find it. So if you want to find out if there's a union representing the firefighters of South Burlington or Colchester, you can look and find that information.
Thank you. Any last questions? Well, thank you so much. Appreciate your time.
Okay, just so you didn't want any input regarding the right to strike. Okay, all right.
If I assume that it didn't occur to me that you would have input on it, but if you do, please go ahead.
No, well, I apologize. My naivete. I was asked here in connection with that. So if the legislature were planning on doing that, my question was whether there would be, or you would want to, a question you might have. And again, I don't want to influence the legislature and what it does and why. But with respect to the municipal statute, there's some limitations or standards for the right to strike. And I would, if you want to look at it, it's under 21 BSA 1730. If this is going, advancing, our case law has developed surrounding that. So in terms of how to implement it, we'd have the tools to implement it. So
thank you. Any other questions by the committee? Well, thank you so much, Judith. Appreciate it.
Okay. Well, thank you very much. Take care.
Okay, take
Bye.
care. Bye-bye. So that concludes our hearings for today. we have nothing after the 4th, correct?
Correct.
And I don't think anything will materialize. Our next hearing will be tomorrow morning at 9 o'clock in the morning. We will continue hearing, we will have a walkthrough starting at 9 o'clock. Keisha Ram will present, Cameron, John Gray, O'Grady, and others perhaps, on 127, which is the Senate's housing bill.
And I'll be swapping with Senator Ron Hinsdale for about 20 minutes because I have to go present down there our bill on unpaid leave.
Oh, unpaid leave.
And
Okay,
then I'll come back.
so, I think, any other last thing?